Your Honor, I have in regards to case number 25F4-523, I have a couple things I'd like to point out about a couple of the matters here today.
Right.
In regards to count 3, MCL 750197, lawfully detained or imprisoned in jail or confinement.
All right, legal eagle spas here. What the defendant's attempting is a statutory interpretation of Michigan law, specifically MCL 750.197. He's arguing that because he was in a hospital, not jail, he couldn't have escaped lawful custody. But here's the kicker. If you're under the sheriff's watch, location doesn't matter. It's not the building, it's the legal status. Thoughts? Do you think a hospital should count as confinement under the law? Sound off below.
Judging by the definition of the statute itself, Your Honor, it compels us to conclude that one has to be lawfully imprisoned or in jail. Jail being a facility operated by a local unit of government for detention of persons charged. At this location, defendant was located in a hospital and not a confinement by government agency or jail. So I'm requesting that charge is invalid.
That was going to be addressed. That would be addressed in preliminary examinations as to the sufficiency of the charge. So if you're making a motion that I dismiss it at this point, that motion is denied.
Okay. Further in count 2 and count 1, actually, Your Honor, both of these were, I don't know the procedural process or when it should get raised, but both of them are Fourth Amendment violations. And furthermore, on count 2, MCL 257.904, that the license of the defendant was revoked or suspended, given the statute as well, Your Honor. That would require the prosecutor to prove that the license was revoked or suspended at the time of the arrest, and that defendant was notified, and that the defendant operated a vehicle on a highway or roadway. I challenge the prosecutor to prove all.
Now that is a triple challenge: license status, notice of suspension, and location of arrest. He's tossing a mini trial into a pre-trial hearing. Smart move. Maybe. Successful. A. The judge isn't biting, yet, but if the prosecution can't prove all 3 elements, this count could collapse. Are we seeing a well-prepped pro se defendant, or someone flailing in legalese?
3.
Sir,
Yes,
do you wish to have a preliminary examination in this?
I'm making sure we're prepared for it, but yes.
What'd you say?
Making sure we're prepared for it, but yes, I am. What are the other options? I'm requesting that all the charges are dismissed. A motion for all dismissal on all these charges.
They're not going to be dismissed.
No. Okay.
So if you want a preliminary examination and make your arguments, then it might be that they would be dismissed at that point. They're not going to be dismissed on an oral motion.
It was already, that all paper discovery happened since Mr. McLuhan in jail. There are USD video, a number of agencies were involved in this case. I believe she's obtained all of those videos, and those will be sent interdepartmental to jail staff to serve on Mr. McLuhan. I expect it to be in interdepartmental mail tomorrow.
Got it. Okay, so we're not ready. He hasn't gotten the videos.
Discovery, I expect that'll happen.
So, Mr. McGill, are you going to have an objection to the adjournment so that you can see all of the discovery that they have prior to setting this for preliminary examination?
Your Honor, I didn't know what hearing I was prepared for today. I was preparing to cross-examine the officers today, with or without the video evidence. So, given that that's not the case and the officers are not here, um, I would like a speedy trial. I would like to invoke my right to a speedy
So
trial.
you want your preliminary examination. Those are coming down to the jail to him.
I expect to have next week. So the court follows its normal setting for preliminary examination.
I would set it for the 19th, and then he'd have them well in advance, and I guess I'll do it that way. Prior to setting the preliminary examination as being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 4 different counts, or 5 different counts, including an eluding 4th degree, which is a felony punishable by up to 2 incarceration and $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 20 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200, no more than $500 fine plus court costs. Count 4, operating with license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days.
Let's pause. Count 5, refusal to obey a lawful order, may sound minor, but stacked with fleeing and eluding, it paints a much more dangerous picture. And did you catch that? July 3rd, 2025. We're talking about back-to-back cases across counties with overlapping charges. This isn't just legal trouble, it's a timeline of chaos.
$500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona, in the city of Milan, Washtenaw County, state of Michigan, that you get up a vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice which transforms this into a felony charge. It's punishable by up to $500, $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service. Any rehabilitative programs the court deems necessary. The court could order you to pay the cost of the prosecution, the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, I just asked, do you still wish on representing yourself, sir?
Your Honor, I do. I will. I have requested assistance, given that I am incarcerated and I have no way to.
You wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be represented?
Well, I've called the
prosecutor. We go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know court procedure. and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I advise you as to the penalty, charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you.
If
That is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public.
Thank you, Judge. To worship feast assistant public defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
I will set. He's asked for examination in the case, and so I will set it. I will set these for preliminary examination.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and
390 days of delay. That's not just a scheduling issue, it's a potential due process landmine. He's invoking People v. Hernandez and U.S. v. Lavasco Beg precedent cases on speedy trial rights. If this delay was tactical by the state, the case could implode. But proving prejudice is tricky. What would you do if your warrant just sat around for over a year?
this triggers due process violations under U.S. versus Lavasco, People versus Bessard, People versus Rosengreen, and procedural unfairness. Sixth Amendment violations, and I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay, or the prong test, is to make sure that there was no undue burden or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. I'm just requesting that the court grant a personal reconnaissance on my behalf, and for both of these charges, being that we're looking really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting a release, Your Honor, PR bond.
And a response from the people regarding his bond.
People would ask the bond to be also fail to appear before judges.
Yes.
Also, with respect to the other, I'll wait. There are pleadings filed by bond to judge. I guess my one remaining point would be, you should, with the court's appointment, Mr. Public Defender's Office, I will make sure that the digital discovery that I have is served on the Public Defender's Office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination and realize where this may be. My understanding is that he is still held, regardless of what the bond would, in this case, he's being held without bond in Judge Slate's case. That his bond has been denied. So
That's what I would
Mr. in any event. But also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger or a risk of flight. Also, the nature of the charges of fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, in this court's mind, the defendant, this court would consider a danger to the public, so to the extent that he is asking that I modify his bond conditions, his bond in this case,
I have,
that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process.
Whoa. The defendant filed a civil suit against the judge, the prosecution, and other officials. Bold strategy or courtroom sabotage. The judge doesn't flinch and calls it a manipulation tactic. This could raise serious questions about impartiality, or it could backfire spectacularly. Would you trust a judge to be impartial after they've been sued by the defendant?